Now, the 8-day detention of accused number 2 in the Senzo Meyiwa murder trial, Bongani Ntanzi, was irregular. That's State Witness Vivienne Cronje says. She noted this while taking down Ntanzi's confession statement. The law states that an accused person should be brought before the lower court as soon as possible, but not later than 48 hours after the arrest. Meanwhile, the defense wrapped up Cronje's cross-examination in the trial within a trial, looking at whether a confession was obtained lawfully. Newzroom Afrika's Mnisi reports.
At the heart of this trial within a trial is whether Bongani Ntanzi's confession statement was obtained lawfully without the violation of his basic rights as enshrined in the Constitution. The Pretoria High Court previously heard that accused number 2, Ntanzi, reported to Magistrate Cronje that he had been detained for 8 days without being taken to court when he made the confession statement. Magistrate Cronje says she noted it as an irregularity.
Why did you proceed with someone who had indicated to you that he was in an unlawful detention from the 16th of June?
He was represented at that stage. He wanted to. It was from him. He's the one who showed that desire to speak or to say something at the time. And at that particular time, I also did not consider it, or also not consider. I also did not see it necessary or deem it necessary to bring the proceedings to a halt.
Pressed on what steps she took upon learning about this irregularity, Cronje said she reported it to the senior magistrate.
You have also, in your examination in chief, if I remember very well, indicated to the accused in various ways that he must feel free and respond to you any irregularities, and you will help him. Now, after telling you this, that he had been kept in an unlawful detention, what did you do as a magistrate to release him?
It was not within my powers to release him. And this particular aspect, I mentioned it, or I reported it to the senior magistrate upon the completion of taking down the confession.
According to the Constitution, arrested persons must be brought before a court as soon as reasonably possible and no later than 48 hours. This falls amongst the rights that the defense says should have been afforded to Ntanzi. Another one is the right to legal representation, which the defense has sought to challenge, saying Ntanzi was not represented. Magistrate Cronje has been adamant that Ntanzi insisted on having his lawyer there during the entire process. Her evidence is corroborated by the principal court interpreter of the Boksburg Magistrates Court, who was present when Ntanzi made the statement.
I remember the presiding officer had a conversation with the gentleman. I mentioned earlier that he was dressed in a suit. As far as I can recall, I think she was asking him who he was, and the gentleman said that he was the legal representative of the suspect at the time. And this was confirmed by the suspect himself after he was asked by the presiding officer. I think after all the pleasantries were done, we then proceeded with the business of the day.
Despite Ntanzi's claim to have been coerced through an assault, Mutlapi says he appeared to have wanted to speak and that he also signed.
When the rights were explained to him, and the fact that he was not compelled in any way to make a statement, his specific words were, I really want to speak. I just want to say this. If I can say it in Zulu, my lord, he said,
both Cronje and Mutlapi concluded their testimonies on Monday. The state is now focusing on the pointing out statement made by accused number 1, Muzika Ukhulelwa Sibiya, who has also objected to its admissibility, citing torture and assault. Lieutenant Colonel Nkosikhona Radebe is currently facing cross-examination, which will continue on Tuesday in the trial within a trial. For Newzroom Afrika on Channel 405, I'm Mnisi at the High Court in Pretoria.